Hello, my name is Kathy Cook. I am the Environmental Policy Director for the League of Women Voters. I thank you all for coming tonight to hear about the Green Amendment in Pennsylvania. During Maya's presentation, please put your questions in the chat. We'll have a question and answer session at the end of the presentation. If you don't have time to answer all the questions, we will ensure that you receive the answers in an email. All registrants will receive a recording of this webinar. Our speaker tonight is Maya Van Rossum. She is the leader of the four-state Delaware Riverkeeper Network and is a very passionate environmentalist. Maya founded the National Green Amendments Movement in 2017 with her publication of her book, The Green Amendment, Securing Our Rights to a Healthy Environment. The book is a gold medal winner for nature conservation from the 2018 Living Now Awards. It was recognized as one of the year's best books for better living and received an honorable mention in the 2017 Forward Indies Book of the Year. Her organization, the Delaware Riverkeeper Network, is the only advocacy organization working throughout the entire Delaware River watershed. Through strong and informed advocacy and litigation, the Delaware Riverkeepers Network champions and secures the rights of communities to a clean and healthy Delaware River and watershed that is abundant with a diversity of life. So with no further introduction, here is Maya Van Rossum.
Oh my gosh, Kathy, thank you for that kind introduction. I feel like I should now turn off my screen and go away in case I don't live up to your kindness. So, well, I really appreciate people coming. I'm sorry, I think the talk was well prepared before the chemical spill happened, but once the spill happened, I've been out and about, focused on that for the entire week. So we will see where we land with the presentation. But I was given a very specific charge, and the question was, how has the Green Amendment in Pennsylvania, how does the Green Amendment make a difference? So that's my focus. And actually, the second edition of the book is just out. It's called The Green Amendment, and now though the subtitle is The People's Fight for a Clean, Safe, and Healthy Environment. And so it's been updated and reworked and new stories and really brought up to speed. So this question of how does the Green Amendment make a difference and where is it advancing gets answered in the book through the stories that I tell, both the need for it, but then also how it's been working. But by making sure we're all on the same page, right? What a Green Amendment is and does, we're not going to go into the language, but a Green Amendment takes the right to clean water, clean air, a stable climate, and healthy environments, and puts them legally and constitutionally on par with the other fundamental rights we hold dear, like the right to free speech and freedom of religion. I always say to people, we all know how powerfully those fundamental rights are protected. Well, now environmental rights are added to the list. It makes sure through its Bill of Rights placement, but also the choice of language, that the rights of all people are protected equitably. And so those who have been disproportionately impacted, they get that extra help, protection, and lift. So we provide this equitable protection. It's not just about lifting all boats and leaving those who are disproportionately impacted still disproportionately impacted. And it provides generational protection, making sure that we are protecting our natural resources for present and future generations. What the strength of a Green Amendment really comes from the overarching protection that it provides, right? The Constitution is above the law. So when you have a Green Amendment, all government action and all government activity must be interpreted, applied, and enforced in service to, by, for the constitutional right of a people to a clean, safe, and healthy environment. So there are a lot of ways to interpret how a particular law is applied and enforced. And it's one of the reasons why we have a lot of pollution and degradation, because all too often our government officials interpret and apply our laws as weakly as possible. Well, when you have a Green Amendment, because there's now this constitutional right to a clean, safe, and healthy environment, and an obligation on government officials to protect natural resources for present and future generations, we really start to strengthen how those existing laws are being interpreted and applied, because now they have to be utilized in service of that constitutional right. The Green Amendment is very powerful legally in terms of strengthening the laws on the books, providing a foundation for new laws and filling the gaps where the law hasn't caught up with critical protections to water, air, and ecosystems, but it's also empowering for advocates, because now when people are advocating for the environment, they're advocating for the people and the earth that they love, but they're also advocating for a constitutional right. So we have that added powerful legal strength in all of the environmental advocacy that's taking place. So now to the question of the night. Does it really make a difference? Yes, it does. People will say, well, boy, Maya, you say that a Green Amendment makes a difference. You know, you're all about there being a Green Amendment in the Commonwealth of Pennsylvania, and yet in Pennsylvania, we have fracking, and we've had our Green Amendment, right, since 1971. So how great can it be? Well, the thing is while the Pennsylvania Green Amendment was added to the Pennsylvania Constitution in 1971, very quickly it was declared by the Pennsylvania courts to literally be just a statement of policy. And the courts determined that if people complied with the statutes and the regulations already on the books, that they were deemed to also be in compliance with the Constitution, that the Constitution wasn't something different and more powerful. And that's not the way constitutional rights work in every other arena, but for the environment, they were saying it's really just policy. If you comply with the laws on the books, you're golden. And that's the way it stood for 42 years. There was this powerful language in the Pennsylvania Constitution, but there wasn't additional critical environmental protections. And it was during that 42 years when fracking, with all of its highly polluting industrial operations, right, its 24/7 noise, light, and pollution, its devastation of our natural landscapes, its water pollution, and air pollution and climate changing emissions, right? All of these devastating consequences of fracking came swooping into the Commonwealth of Pennsylvania during this 42-year period. And so Pennsylvania communities got overwhelmed by this fracking industry, because the way the law was written in Pennsylvania, both state law and federal law, it really did allow a tremendous amount of fracking to take place, and do so in a way which was tremendously harmful to public health and safety, to property values, but most importantly, to our environment. Despite that, it really was, given the state of the law, pretty easy for the fracking industry to come and have their way with Pennsylvania's environments and communities. The fracking industry wanted to find a way to make it easier for themselves. And so they literally, leaders from the fracking industry literally went behind closed doors and wrote a piece of legislation that in 2012 was passed by the Pennsylvania legislature and signed by Governor Corbett, which made it easier for fracking to advance, because it changed the legal landscape and made it even weaker for the frackers. So it put in place automatic waivers from environmental protection standards. It preempted local zoning. And so while for other industries, municipalities could say, hey, listen, if you're going to come into our town, your industrial operation needs to be placed in the same location as all the other industrial operations. By virtue of this state law, that ability for municipalities to have a say in where fracking took place, that was preempted and taken away. And the state law mandated that fracking be allowed to happen in every part of every community, in its residential districts, its historic districts, its environmental protection zones, right? Its agricultural areas. Nowhere was off limits to this industry with the passage of this law. The frackers no longer had to notify those on private drinking water wells that their drinking water had become potentially contaminated by fracking. And there was more. Suffice to leave it to say that, right, the law was already weak when it came to fracking, but with the passage of this law that was called Act 13, it became even weaker. And so things were really going to get exponentially worse for Pennsylvania's communities and Pennsylvania's environments, because more fracking would happen more quickly and more easily. At the Delaware, now, when a law is passed by a legislature and signed by a governor and goes into effect, there really are not many options for those of us in the public who, can see what harm and devastation it's going to bring. Often people are left to protesting, trying to get their government officials to repeal the law they just passed or amend the law they just passed. Well, repeal and amendment wasn't going to happen. Protests were already happening. It wasn't changing their minds. So, you can try to elect better people to office so that they, down the line at some point, somebody will do right by the people of Pennsylvania and its environments in terms of amending or repealing the law. But by that point, it's too late. So there really, when you actually have a law passed through the political process in place in our nation, there really are not many options to take it on if you can see that it's going to inflict devastating harm. And that's sort of the situation we were in the Commonwealth of Pennsylvania when this Act 13 was passed. But at the Delaware Riverkeeper Network, we have been fighting fracking for a long time, right? That's another story, but I would proudly say one of the reasons we don't have fracking in our watershed is because of my organization. But we know that fracking anywhere is bad for all of us everywhere. So we knew that when this Act 13 had been passed, we had to find a way to challenge it. And we reflected, when we were reflecting on our legal strategy, we reflected on the fact that we had in the Pennsylvania Constitution this long ignored constitutional environmental rights amendment, Article 1, Section 27 of the Pennsylvania Constitution. And we thought, this pro-fracking law is so egregious, is such an overreach, that maybe we were in a moment in time when we could get the Pennsylvania courts to recognize that they had set bad precedent that 42 years before, and it was time to change that precedent. It was time to reinterpret Article 1 section, or properly interpret Article 1 Section 27 as really providing a meaningful right of the people to a clean, safe, and healthy environment. So when we were figuring out how we were going to challenge this law, that was the argument that we at the Delaware Riverkeeper Network decided we were going to, amongst other things, really focus in on. That this law was a violation of Article 1, Section 27. There were 7 towns that also wanted to challenge this law, and they joined us in this litigation, and they had additional arguments that they brought forth. But the Article 1, Section 27 was a focal point for the Delaware Riverkeeper Network. The case went all the way up to the Pennsylvania Supreme Court, which was very conservative at the time. And in December of 2013, we got this amazing landmark victory written by the Chief Justice of that court, the plurality opinion was, where the Chief Justice wrote that by any responsible account, the exploitation of the Marcellus Shale Formation will produce a detrimental effect on the environment, on the people, their children, and future generations. And that the natural resources that were being harmed by fracking in Act 13 were resources essential to life, to health, and to liberty. And that as a result, the core provisions of Act 13 that we were challenging would in fact violate the Pennsylvania Constitution, and therefore were unconstitutional and could never go into force in effect. We stopped those provisions before they even started. And not only did we do that, with this victory, we literally overturned that 42 years of bad precedent and breathed legal life into that long ignored constitutional right of the people of Pennsylvania to pure water, clean air, and a healthy environment. We totally changed the legal landscape, and we defeated a law that, but for the Pennsylvania Constitution, would have remained in play and in place. It was in the wake of that victory that I really founded my Green Amendment movement. I looked at what was unique about Pennsylvania's Constitution. And then I looked at every constitution, what was unique and allowed us to achieve this victory. I looked at every constitution across our nation and found that at that time, only Montana had an amendment similar to what Pennsylvania had. That there were a lot of other states that talked about the environment, even environmental rights, but only Pennsylvania and Montana lifted up environmental rights to that highest constitutional standing. Since founding the Green Amendment movement, writing the 2 books, the movement is really taking hold. First off, we passed a green amendment in the state of New York. So that started to go into effect last year. We've got about a dozen other states where green amendment proposals have been put forth. And then we have even more states where interest is growing and people are asking and or getting organized. So the movement is really powerful. People just know in their hearts and in their minds, right? We're all sick of being told we have a right to clean water and clean air, and that not actually being true because it's not a right that can be enforced. But with a green amendment, you make it a right that can be enforced, and people see the power in that. So that's why this movement, it's one of the reasons why this movement, is so empowering for so many. So now, how has a green amendment made a difference beyond that Act 13 challenge? Well, first off, in a number of cases, the amendment is not just relied upon by people like me and organizations like the Delaware Riverkeeper Network. Often municipal governments are relying upon the amendment. I told you about the 7 towns that joined us in our case, where they were full on board with our green amendment arguments. And also we see state government and state government officials relying on the amendment in a variety of ways. So I want to make it clear, it's not just about the people, right? Everybody is getting the benefit of this. So what are some of the other victories? Well, there are actually 2 cases in the state of Montana that are like a decade apart, 2 decades apart. They're very far apart. And where industrial gold mining activities have been given a permit by the state regulatory agency. In one case, it was to do industrial gold mining along the Blackfoot River. And in another, it was in a remote natural ecosystem outside of Yellowstone National Park, an ecosystem barely touched by people, if touched at all. And in both of these instances, if this industrial gold mining had been allowed to advance, there really would have been devastating consequences for these critical environments, for the communities that depend upon them, for the critters that depend upon them, and also for local economies that depend upon healthy environments in Montana. In each of these instances, the Green Amendment was relied upon to challenge the permit that had been issued, in part because the state had not done the necessary reviews to determine the extent of the environmental consequences, and or because there was demonstration that the consequences would have been significant. Now, of course, every legal case is nuanced and complicated, so I'm not going to delve into the ins and the outs, but that's really the long and the short of it. And using in very significant part the Montana Green Amendment, the permits for each of these 2 projects, again, decades apart, were voided, were taken away, were declared unconstitutional, and so were not able to go into force and effect. It was then incumbent on the regulatory agency to say, okay, we hear you, we issued an unconstitutional permit, we're going to go do the work to issue a permit for these projects that is constitutional and that will allow them to advance and meet the constitutional obligation at the same time. Well, in neither of these situations was that permit reissued. And so to me, what that suggests is that when the state actually went back and did the work, they realized that the consequences would have been devastating and that it was not the right thing to do to issue those permits. And so we avoided all of that irreparable harm before it even started. And these projects are not, in fact, and have not, in fact, moved forward. Here in the Commonwealth of Pennsylvania, the Pennsylvania government was co-opting funding that was coming into the government coffers from the leasing of public lands to fracking operations. There was a legal and the government, the legislature decided that they were going to take these funds that should have actually been for natural resources protection, and they were going to use those funds to fill a gap in the general operating budget. The Pennsylvania Environmental Defense Fund challenged, and based on the nuances of the law and the budget and the Green Amendment, they said, look, this is a misappropriation of funding that should go to natural resources protection. And the court agreed. And so those funds, in significant part, not in total, but in significant part, were deemed to be more appropriate for natural resources protection, and they couldn't be co-opted for just any old thing by the government. And if you can co-op right money just by leasing off to industry, that really incentivizes the leasing off to industry. So this was really important that this determination was secured. In Pennsylvania, again, Marple Township, Delaware County, that is a suburban community that's quickly urbanizing. It does not have much green space left, but it does have a significant parcel known as the Don Guanella Woods, which had a high quality stream, the Whetstone stream that flowed through it. And the Archdiocese owned the property, and they decided they were going to sell it off for a big development. And so this last critical ecosystem in Marple Township was about to be lost. And it turns out that you didn't only have this high quality stream, right, and this beautiful natural woodlands that the people enjoyed, but there was actually an old growth beech tree forest in there. So there was a lot of advocacy by the community saying, don't let this development, use your municipal authority to say no. They argued based on, or we argued because the Delaware Riverkeeper Network was part of it, based on, township ordinances and laws, but also argued that Article 1, Section 27 of the Pennsylvania Constitution really gave the municipality the power to say no, especially when meshed with the ordinances that they had in place. And ultimately, after a couple of years of advocacy, the municipality agreed and they rejected the development project, and municipal officials cited Article 1, Section 27 as a core underpinning of why they felt they could make that decision. After the project was rejected, there was then time and space to actually get this parcel purchased as public natural open space. So it's now permanently protected. But that wouldn't have happened if the people didn't have the strength of Article 1, Section 27 to help them get that no vote from the municipal supervisors. In Montana, there was a contract between a landowner and a private developer. And this contract required that in order for the deal to go through, to support the development of a hotel and some other things, there had to be a test well drilled to determine if there was a drinking water supply. As it turned out, when the research started to be done about the site and about the property, it became clear that there was a chemical plume in the aquifer under this property, or not under, but connected to this property. And that plume was also connected to the drinking water supply of the town of Bozeman. And had that test well been drilled, that the flow dynamics of the aquifer would have been changed such that that pollution plume would have potentially been pulled into the drinking water aquifer that supplied drinking water to the entire town of Bozeman. And so all the people of Bozeman might have ended up with toxic water as their drinking water supply. And the gentleman who owned the property, who had to do this test well, he would have been, at risk of being liable for all of the devastating consequences. So he didn't want to have to drill that test well. And you know what? The environmental agency of the state and the judges didn't want to force this test well either, because it put at such risk the entire town of Bozeman. The court, when asked to reflect, was able to, in very significant part, turn to the Montana Green Amendment to say, look, the people have a constitutional right. And if we enforce this obligation, we are infringing on the constitutional right of the people of Bozeman. So there, the state used the amendment to protect themselves from having to force and enforce this drilling obligation that was part of a contract and a mandate of law, because it would have resulted in a constitutional infringement. We have in East Whiteland Township in Chester County, Pennsylvania, there's a toxic site known as the Bishop Tube site, supersaturated with trichloroethylene and a spreading pollution plume leaving the site. This site has been in this toxic condition since the mid-1980s. And the Pennsylvania Department of Environmental Protection knows it and has known it. A number of years ago, about a decade ago, rather than they had a developer come to them and say, I want to develop this site with over 200 residential homes. And rather than say, no, this site is toxic, and use existing law, the Hazardous Substances Cleanup Act, to force known responsible parties who have gobs of money, Johnson Matthey Corporation and Whitaker Corporation, rather than enforce this existing environmental law and say, you have to clean up this site, hold off on this development project, the Department of Environmental Protection decided that they were going to continue not to worry about the responsible parties, and that they were going to negotiate a sweetheart deal with this developer that would allow him to develop this toxic site while it remained in its toxic condition, with no plan to clean the site up and bring new families to this site and be potentially exposed. So the Delaware Riverkeeper Network joined forces with families like the Stauffer family and the community of East Whiteland Township to take on this battle. And at one point, part of our strategy has been to file a legal claim to say that the failure of the DEP to enforce existing law to secure cleanup of this site was a violation of Article 1, Section 27 of the Pennsylvania Constitution. And the state tried to say to the court, well, listen, you should dismiss this case because we're not taking action that violates the Constitution. We're simply doing nothing. And the court said, no, doing nothing is doing something. You are choosing to do nothing, right, to enforce this existing law and honor the constitutional obligation. And so the court refused to dismiss our case. Now, there have been a lot of ins and outs and steps forward and backwards with regards to this site. But the notable thing when it comes to Article 1, Section 27 is because we had the amendment to rely upon, we were able to undertake that legal action, have that debate about inaction being action, and the court standing with we the people to say that this case should remain alive and well. Not be dismissed because the state had chosen to do nothing. And the end result is, at this point, the sweetheart deal has been quashed. The developer is still trying to develop the site. But the state is now enforcing and has put forth a remediation plan for the toxic contamination at the site. And there are a lot of hurdles that would have to be crossed for that development to happen because of this toxic condition. But this step of the state to make sure that this long ignored toxic site actually gets remediated all happened because we were able to rely upon Article 1, Section 27. In the state of New York, I told you they just got a green amendment. There was just a case decided about a month ago. No, 2 months ago. And there's a town that's located next to a massive landfill for the city and for businesses. And for years, they had been complaining to the State Department of Environmental Conservation about the noxious odors, the dangerous air emissions, the greenhouse gas emissions that were coming off of this landfill, complaining about the fact that the state was not enforcing steps that would prevent these harmful emissions to the community, and that in fact the state kept approving expansions of this landfill. And these people use the advocacy and the law and legal arguments, court arguments, based on existing law to try to get the state to act in a meaningful way. And they always lost. New York Green Amendment got passed, giving them a constitutional right to clean water and air and a healthful environment. And now the people went and brought a legal challenge and said, listen, the state's actions and inactions when it comes to existing law and this site are resulting in a violation of our constitutional right to clean air and a healthful environment. And the state, no surprise, came to the court and said, no, we're making sure the laws are complied with as we interpret them and enforce them. and you should dismiss this case. And the court said, no, I'm not going to dismiss this case because the people really did bring forth meaningful legal arguments. The court said that the state is not allowed to violate the Constitution or the constitutional rights of people, and that there was enough evidence here of a constitutional problem that this case should remain alive and well. And so this, again, it still has to move forward, right? This situation is very dynamic right now, but up until this point, just using existing law and the way the state was interpreting it and applying it, the people had lost. And they were left to suffer with this harmful condition. But once they got this right to clean air and water and a healthful environment, and they were able to demonstrate that the state continued to act in a way that was resulting in a violation of their constitutional right because of how the state was interpreting and applying the existing law, allowing the site to expand, things that they weren't doing that they could have been doing under existing law to address the problem, that when you roll all of that together, that results in a constitutional problem. And so this case, these people are now able to take on this really harmful condition because they have a New York Green Amendment. Up until that point, that was it. They were done because the power of interpretation and enforcement was left into the hands of the government. And the government said, we're complying with the laws and the regulations on the book. Done deal. You lose, we win. When you have a constitution, a constitutional right, the power comes back in very significant part to the people. Just Marple Township, go back to Marple Township. There was just came out March 9th. The Public Utility Commission had given approval for a natural gas transfer station to be located. No, it wasn't approval for that. This was another step about whether or not township zoning authority would apply to a natural gas transfer station. And depending on the nuances of the law, the PICO was saying township zoning did not apply. There were arguments that it did apply. There's lots of ins and outs. The law is always complicated, but the long and the short of it is, in rendering their decision about whether or not the municipality could or would have any authority here and what the PUC's decision should be with regards to this station, the township was saying that the PUC needed to consider the environmental impacts that the township was raising for their residents. And the PUC said, no, we don't have to consider that. That's not under the municipality's planning code pursuant to which we're operating. We don't have an obligation or a right to consider the environmental harms to the community. So they didn't factor that in, right? We're not going to go into the ins and outs. They didn't factor those environmental issues in. And Marple Township challenged and said, you're constitutionally obligated to consider the environmental impacts on our community of your decision in this context. And the court came back and said, yep, yes, you are. Because while the municipality's planning code might not require it, the Constitution does. And all government entities in the Commonwealth of Pennsylvania must ensure that the Constitution is complied with. And so now this case is continuing to go through the process, but Marple Township now has the ability to ensure that the environmental implications of this facility is being taken into consideration while the PUC is undertaking the current decision-making that they're undertaking. In Pennsylvania, we now have some of the strongest PFAS drinking water standards that have been put forth. I'm proud to say that's all the result. It all started with the Delaware Riverkeeper Network petitioning the state to have to do this. One of our arguments was that the state's failure to address PFAS contamination was a violation of the environmental rights of the people of Pennsylvania. Another situation, lots of ins and outs, lots of advocacy, lots of litigation, lots of decisions along the way. But the long and the short of it is, at this point, the state has been persuaded that PFAS protections are necessary, has put them forth. And when you look at the governor's determinations and other determinations advancing these drinking water protections, you will see all along the way government saying the people of Pennsylvania have a right to pure water and a healthy environment. It is our duty, constitutional duty, to protect it. And they grounded a lot of what they did in Pennsylvania's Constitution. So it was a real powerful positive for advancing this critical protection. The Attorney General's office routinely cites Article 1, Section 27 when they're enforcing environmental protection laws here in the state of Pennsylvania. And in fact, when the Attorney General is talking to other states, about things to do, proudly, even the new Attorney General proudly saying Pennsylvanians have a constitutional right to clean air and pure water, and I am committed to defending that right. We are really starting to see more and more government officials in the Commonwealth of Pennsylvania embracing their constitutional obligation. So we're getting better decisions, and we don't have to go to the court all the time to challenge the bad decisions, because they're now proactively making positive decisions. And that's really the goal. We don't want to have to bring more lawsuits. We want to get better decisions that avoid harms and therefore avoid the need to bring forth litigation. So those are just a few examples of how having a green amendment in Pennsylvania, Montana, and New York really is making a difference. Like I said, it's all in the new book, the Green Amendment, The People's Fight for a Clean, Safe, and Healthy Environment. So if you're interested, you can get it. And our Green Amendment movement is really advancing very powerfully, like I said, in over 15 states now, in a really meaningful way. So I hope I've convinced you this is a good thing and you should get on board with it. I mean, you are on board with it, but answer the outstanding question. Does it really make a difference? Yes, it does. Yes, it does.
Maya, this was very, very helpful. I was wondering if you can just add some comments about the recent chemical spill. You were talking about that.
Yeah, right. So there over 8,000 gallons of a latex emulsifier with a number of dangerous chemical constituents was released to the Delaware River. Well, released to a tributary to the Delaware River called Otter Creek, entered the Delaware River Friday night. And so now it's been really a matter of what are the implications for drinking water and or the environment. And I think the things that I can tell you is, there's been a lot of confusion because there's been a real lack of information coming forth out of our government agencies. Most of the conversation has been around Philadelphia drinking water supply and whether or not it's safe. And what we have seen is the Philadelphia Water Department coming out pretty late with information and then offering confusing information. The water is safe. Oh, maybe you should buy bottled water. The water is safe. Oh, well, you might want to consider bottled water. I mean, it's been like really just back and forth for the last couple of days. And that confusion has led to mistrust by people and people really not knowing what to do. And at moments feeling very panicked because they thought they were drinking toxic water all this time because they should have been drinking bottled water, but nobody told them. But then it was safe, but then it wasn't safe, right? It's been back and forth. So the state is really, or the city is really trying to rehabilitate their credibility here. And that's the press conference I was on just leading up into this event. So, I think that at this point, they talk about the water being safe until a time certain. And and that time certain seems to keep changing. And that has to do with modeling about where the pollution plume is in the river. But I do think that the water department is working hard to test the water, as are the other water intakes, to test the water and make sure it's safe. But I do think that there is a level of distrust because of a dearth of information and conflicting information. Most of it's coming out of the Philadelphia Water Department. We're not really hearing about it from the other water purveyors. Why not? I don't know. And so it's a little bit scary for people. the drinking water, of course, is very, very important, but also is the impacts on the environment. And one of the things that we are seeing at the Delaware, or really not seeing at the Delaware Riverkeeper Network, is we're not seeing the U.S. Coast Guard, the Department of Environmental Protection, the Environmental Protection Agency, and the other involved agencies coming forth with any information about the natural resource monitoring that should be taking place. I mean, this was a direct discharge to Otter Creek. At the mouth of Otter Creek, which is also called Mill Creek, is the Bristol Marsh. It is one of the last few remaining freshwater marshlands in the region. It's got six rare species that were almost lost to our region. The water, flows right by there, and then it's at the mouth of the Delaware River, and at that point the Delaware River is tidal, so this stuff will be sloshing back and forth, but we're not hearing about any testing or data collection or review or analysis for what is happening ecologically. So that really has us alarmed at the Delaware Riverkeeper Network. And the other thing that really has me alarmed is the fact that that the way the incident command is advancing right now with this spill, it's not characteristic. When there are catastrophic spill events of this kind, there's a list of people that are supposed to be notified. I'm among them. And there's good reason for that. That's so we can help interact with a lot of people call me. They're not calling the Coast Guard. I can give them information. The press calls. If we think that the government's not, if people are witnessing things out in the community that might be helpful, they might not call the Coast Guard, they'll call us. We can make sure we pass that information through. If there's a valid role for volunteers or monitors or witnesses, right, to be keeping their eyes and ears open out in the community, we at the Delaware Riverkeeper Network can help inform, encourage, organize that. We can also tell people, don't go out and do anything because you're going to, put yourself in harm's way, or you might undermine the emergency response. So there's a really important role that we play when these things happen. I never got the call, and I still haven't gotten the call. And so, that's sort of for me where it started was I never got the call. And now what we are also seeing is the Coast Guard. I've seen one press release, the Department of Environmental Protection. I've seen one press release. We're seeing the Philadelphia Water Department be very proactive now with information sharing, but Philadelphia is just one of community of many, right, that are in this region. And of course we do have the whole natural ecosystem that we're concerned about. So I think a lot of the problem right now is there's a whole lot we don't know because the response here has not behaved the same way it has in other situations. In other situations, you have an incident command, the United States Coast Guard is in charge, certain people are informed, the agencies are coming out, working together, coming out together to provide accurate, clear information on a regular basis. People know where to go for resources. There's a whole lot that happens that's not happening here. And it's one of the reasons why we have confusion, upset, a lack of trust. I think we also at Delaware Riverkeeper Network, I have a lot of questions about, we hear it's 8,000 gallons spilled. We're given the rationale as to how or why it spilled. I'd like to know what the department is doing to verify all of that information. I don't just rely on the company to tell me how much, they've spilled. Like, I would like to know what the state and federal agencies are doing to really assess what the company is telling them. The other thing is the company is saying that they're planning to restart operations in the next day or few. So I want to know from the Department of Environmental Protection, have you verified why this incident happened? Are you sure it can't happen again? It won't happen again? Have they fixed the problem? So there are a lot of outstanding questions. I don't want to see this company go into operation until we know that there's no chance, that we can have a repeat of this. So anyway, that's sort of how I'm feeling about it. A lot of it is, there's a lot we don't know, and we don't know it because the incident command and the federal and state agencies involved are not doing not doing right by their trustee obligation to protect we the people, and all of them. And right? They work for us. The company is trying to make profits, but the state and federal agencies are supposed to prioritize us. And I really don't think they're doing that right now.
Wow.
So.
There's not much that we can do about this. I mean, what can we?
Well, I think that the outcry is really important. And I'm glad you asked that question, because I actually just today wrote a letter and have been thinking more about that. I think part of the problem is right now it's very dynamic and the incident is happening. And this chemical is going to be out of the system, you know, in the not too distant future, because it's a river system that's flowing out, right? So I think we are thinking about, you know, what are we going to do to make sure that these agencies don't behave this way again next time? Because there will be a next time.
Absolutely.
So, yeah, there'll be some action alerts and things, I'm sure, on that. I'm glad you framed it that way, because I'll make sure that I'm thinking about that. I think right now we're just trying to focus on what's happening right now and hold the officials accountable and get them to get out there with information and real action.
I know the league would be very interested in helping, because we really want to see that all our citizens are protected and consistently. We've had the train derailment. That was kind of a debacle. Here we have another debacle. So we really need to make sure that citizens have a clear path to find out the information. So.
Yeah, and if everything's going well and they're collecting all the data and everything, great. Make sure the people know that, right? Like, give people the information so we can protect ourselves. But no information or conflicting information, or we'll let you know when we know. I mean, you know, it was we've been hearing the city say we've been over communicating. Maybe that's our mistake, is over. No, you have not been over communicating, right? You know, you haven't been communicating clearly. You've been giving conflicting information, and frankly, you were slow in coming to the table in the first place. So by the time they first started to talk about the problem, it was, you know, it was already well into it. And so people are like, what? Drinking water might be impacted, but I've been drinking the water all day.
Yeah.
So once you break that trust, it's a problem.
Very, very hard. I'm going to ask anybody that's on the call if there's any questions. I don't believe so. We will be sending this out to our registrants, and we would like to do whatever we can to help your work, and we follow your work, and we applaud what you do, and we thank you for coming tonight.
Well, and the respect is mutual. I really appreciate the league and everything you do, and you know, such great partners on so many fronts. So it's great to work together.
Very good. You have a wonderful night, and thank you for all you do.
Thank you. Take care.
Take care. Goodbye, everybody.
Thank you. Goodbye, everyone.